First off, it is wrong to title a document Mr. and Mrs. Dickson Omaiye, for instance.
For instance.
It is wrong. The law does not accept that. There is an authority to that effect. I can't remember the name of the parties, but the authority says a property can be addressed as Mr. Dickson Omaiye and Mrs. Martha Dickson Omaiye.
That would be...
It brings both parties together as co-owners of the property, but not as Mr. and Mrs. Dickson Omaiye.
In a scenario where it was Dickson who bought the property.
No, if it is Dickson who bought the property, it will definitely be in my own name and not co-owned. But the moment a property is co-owned by a couple, it will bear Mr. Dickson Omaiye and Mrs. Dickson Omaiye. And both parties will sign the document.
Welcome to Unfiltered, where we say it as it is. I am Emanuela Okechukwu. Today, we are taking a closer look at property and inheritance laws in Nigeria. How can you protect your assets from being contested, tampered with, or mismanaged? Who has the legal right to one's property after death? According to the 2022 Nigerian Bar Association survey, about 70% of Nigerians die without a valid will, leaving their families to fight over land, houses, money, etc. In fact, inheritance and land disputes make up nearly 30% of civil court cases in the country, and these cases can drag on for years. So we will be unpacking the key legal knowledge and rights that can help protect persons' inheritance. Joining me is Dickson Omaiye, who is a lawyer of vast and wealth with experience spanning a period of almost 2 decades. He has worked for 4 different senior advocates before establishing his law firm, the Attorneys Law Firm. He is also the founder and CEO of Duty Notes and Advoca. You're welcome to Unfiltered,
Thank
Dickson.
you so much. Nice to be here.
To begin this, my first question will be, how does one use the law to protect themselves from, entitled family members, even while alive and after death?
First off, it is important that people should protect their estates while they're alive before demise. And how to do that, I would encourage people to write will. It is better to write a will before departing this earth, because to a very large extent, the will speak even after the demise of the deceased, the person. So it is better, although there are laws that protect the rights and privileges of heirs after the demise of the deceased. So there are ways that there is the administration of estate laws and also intestacy succession laws, and most states have domesticated these laws. Okay. Although these laws are still fighting tooth and nail against customs and traditions of most regions and even Sharia laws. But these laws, to a very large extent, protect children, protect spouse, and protect heirs of a deceased after the demise. So somehow these laws are there and established in order to protect, and the courts are there also. And we have authorities, judicial authorities, that now protect the rights of heirs to inheritance.
Does this law come to play if there's a will? Or
no, it does not come to play. The law comes to play if a person dies without a will. It's called intestacy law. That is, someone dies without a will, it's intestate. The person died intestate. So this law can only become applicable where there is no will.
There is no will.
Yes.
Can a will be contested?
Yes, a will can be contested. A will can be contested if there is doubt as to the genuinity of the will. But it is difficult to establish because the author of the will is no more there. Because the will is the only document that starts speaking when the person who writes the will, the testator, is dead. So it's
quite difficult to
contest it, you know, because there are basic things that you look out for. The question, you ask a lot of questions, like the sanity of the person who wrote the will. Was the person in his proper mind when he wrote the will? The signature can be put to forensic test if that is the signature of the deceased or the testator, and other things can be used as a check if that will actually is a correct, genuine will.
So in a situation where unfortunately and finally the will was able to be contested, how can someone use the law to correct what was changed on the will?
Now you go to court, because the court is the avenue. If you suspect that a will is not genuine, if you suspect that the testator did not write that will, you go to court and then you bring your strong argument, your evidence. For instance, if you think that the signature is doctored, then you establish your proof. If you have the original signature of the testator, you present it. They bring a forensic expert who will analyze the signature and tell if the signature is genuine or not. And also, the mental capacity of the person. The question is, as at the time you purportedly said, because the lawyer will definitely be there to read the will. So at the time you said this will was written, you begin to ask, was the person in his right state of mind when he wrote that will? If the person is not in his right state of mind, then you begin to question, particularly certain sharing formula of the distribution of the estates. You begin to question. But there is little you can do. It is only the courts that can determine if a will is real or if it was tampered with.
Oh.
Yes.
All right. Most times we all can say that what leads to some of these things, family problems, fighting over land, is usually, sentiment. So how can one look beyond family sentiment to fight what rightfully belongs to them?
It is difficult to go against family heritage. Now, you see, family comes very key in the distribution of estates. Why do I say family comes very key? Customs and tradition is established through family. And when a person dies without a will, the law of estates, the administration of estate law comes to play. You see, even in the distribution of estates, you must consider family. But you see, this is how it works. Who are the persons that are entitled to inheritance? First, the children. Legitimate children, including adopted children.
If the will states that, because I believe some people might not want to will certain things to their children.
If the will states that, you don't contest what the will says, except you are saying the will is not the original will or it's not genuine. But if the will says, this is how I want my estates, my assets, including liabilities, to be distributed, because a lot of people die with liabilities. So it's part of it. If you say, this is how I want my estates to be distributed amongst my heirs, except you say with your strong evidence that this will is not genuine, it must be obeyed. It must be obeyed. There are a lot of cases, a lot of current cases that are still being dragged here and there. I don't want to give, there are some that are sub judice, the matters are in courts, and it will not be nice to begin to talk about some of these cases, but once there is a will, except there is no will, and if there is no will...
Yes, I was going to ask about
if there is no will, this is what the intestacy laws of most of the states says, and I will take from, let me take from the southeastern states. You see, before the courts came into most of these matters, it was like a crime for a female heir to inherit property. Then it was like a crime, because then women were seen like chattel, subject of inheritance. It means that when a man dies, his brother could inherit the wife, and she does not have a right to inherit property. That was then. But now there are authorities, Supreme Court authorities, that allows women to inherit property. Section 42 of the 1999 Constitution, as amended, provides that you should not discriminate based on sex, gender, ethnicity, and maybe circumstances of birth. So the Supreme Court has hinged, relying on the provision of this constitution, section 42, to give judgment to say women too are entitled to inheritance. But you see, it's difficult to enforce, because if I go to court to say my father's daughter or my sister cannot inherit, now whatever the Supreme Court determines, it's binding on me. It does not bind the other man whose father died without a will and whose sister wants to be part of the share, except he goes to court to enforce that. So does it mean that everybody must go to court before they establish it? Now the law, the judgment that affects me because I went to court, got judgment, does not bind the other person because his name is not in that judgment. And also when you take it to, when you go to Southwest, it's different. In the Yoruba traditional customary laws on inheritance, it focuses first on the first male child. Now, the first male child here will serve as a trustee. But you see, the male children will have equal shares.
All this can be averted if there's a will, right?
If there is a will, of course.
So we're talking about when there is no will
when there is no will.
provided.
Now, if I'm talking about customary laws of inheritance, if I'm talking about administration of estate laws or intestacy succession laws, I am talking about laws that come to play where there is no will.
Correct.
As long as there is a will, these laws will not override the
will that has been stated.
Yes, because the will is the decision of the person who is now late. And because this document only speaks at the death of the testator, nobody, not even the law, can change it except the will is not genuine. It remains and it binds whoever.
All right, moving on. In the case where couples buy a property or owns a property together, but the property is regulated as Mr. and Mrs. in the man's full name, is this an advantage to the woman in case of divorce or death?
Okay, first off, it is wrong to title a document Mr. and Mrs. Dickson Omaiye, for instance. It is wrong. The law does not accept that. There is an authority to that effect. I can't remember the name of the parties, but the authority says a property can be addressed as Mr. Dickson Omaiye and Mrs. Martha Dickson Omaiye.
That would be...
It brings both parties together as co-owners of the property, but not as Mr. and Mrs. Dickson Omaiye.
In a scenario where it was Dickson who bought the property.
No, if it is Dickson who bought the property, it will definitely be in my own name and not co-owned. But the moment a property is co-owned by a couple, it will bear Mr. Dickson Omaiye and Mrs. Dickson Omaiye. And both parties will sign the documents. So in the event of it being contested, maybe as a result of a divorce, and all that, it will be all stated out. These are documents that will be before the court. We co-own it. It's there. So it will be shared. Now,
in a scenario where they didn't know this,
yes.
It's not everybody who has this certain knowledge. In a scenario where they didn't know this, and it's
Mr. and Mrs.
Mr. and Mrs. Dickson Omaiye.
You see, okay, let me say this: that ignorance of the law is not an excuse. Do you understand? Even though this is an error, what the law considers is who signed. For instance, if it's going to be co-owned and it's Mr. and Mrs., it means that both parties will have their signatures appended on it. And that is what the law looks at.
Well, okay.
Yes. Even though that mistake has been made. If the law wants to bend backwards a bit to say, okay, in this scenario, what do we do? The law considers signature. And you establish, the woman also can establish, look, my money is in this too.
In a scenario where the signature is just still Dickson Omaiye.
That may be difficult to establish. It may be difficult. The man may just say, I just put her name there. And if it's the man's signature that is just there. But you see, when it comes to divorce, it's totally different. Because the court wears a human cloth to consider some of these things. You see, when was this property purchased? Was it purchased during the pendency of the marriage? Does the woman have the capacity to contribute to the purchase of the property? Does she work? Does she earn? If she said, yes, I contributed to this, how did you contribute? Did you transfer money to the man? Or did you give him cash? Some of these things come to play.
If it was a divorce case, not a death case at this time.
Now, if it was a divorce case. Now, even if it's in the event of death, all this can be established the same way. We can establish that, look, my money was there, we contribute, we both own this property. Yes. So even if the family is contesting the property with a woman, these are some of the issues that you bring to the table or you present before the court. They say, look, we co-own this, my money is in this, the property was purchased during the pendency of the marriage, which is key. You begin to ask, when was the property purchased? If the property was purchased before. Now, and that brings to bear also the issue of the administration of estate laws. If the man died without a will, and then there's a property that is co-owned, Mr. and Mrs., all this comes to play. Are there children to the marriage? Which automatically gives them entitlement to the man's assets. First, the family does not, when I mean family, extended family does not come to play, does not come to contest assets and liability. Immediate. First thing is children, then the spouse, then before you talk of parents of the deceased. If there are no children, then you can start talking about the wife. In Islamic law, the woman is entitled to 1/8 of the assets of the deceased if there are children in the marriage. If there are no children, she's entitled to 1/4 of the assets of the deceased. So this will come to play if we talk about administration of estate laws. But in this regard, when we talk about in Islam, we're talking about Islamic law as it relates to inheritance.
Now, if a man has a child from a previous marriage, but acquires property only in his second marriage, what is the legal standing of the child from the first marriage if there is no will? Can he lay claim to the properties?
Okay.
The first child.
Now, the question you would ask is the child a legitimate child? If yes, the child is entitled to the sharing of the assets of the deceased.
The child came before his second marriage, where he acquired the property.
Yeah, it does not matter. It does not matter when, as long as the child is not when the child was born, even before the acquisition of the property. it is that the child is a legitimate child. If the child is not a legitimate child, in fact, if an adopted child can be entitled, why won't a legitimate child by birth not be entitled to assets of the deceased?
So as long as there is legitimacy.
Exactly. That is what the law checks.
In a scenario where the second marriage, the wife is contesting, fighting over it.
The law is straight. The law is there.
Now, what legal evidence or documentation can a woman present to reclaim ownership of property she purchased herself, but publicly attributed to her husband, especially if his family accuses her of forgery after his death?
Okay. You see, what happens out there in public does not matter. What is key is, you say you're the owner of this property. What are the documents? Now, is the property approved, government-owned approved property, or is it a local property? For instance, properties that are not registered with government, that are customary property. There are customary property where you need to establish the deed. It's what we call deed of assignment, power of attorney, to show that you purchased it from someone and he has transferred title of that property to you. You know, in that regard, there will not be a C of O because this property is not registered. It's not, for instance, in Abuja, there are properties that are regulated by AGES, FCDA. These are properties in government areas. You must have either the R of O or the C of O. Now, if you purchase the property and you have not changed the title to the name to yours, but there are other documents that will show.
Present. And
some of these things, like the power of attorney, must be registered with AGES. It must be registered in other states. It must be registered in the Ministry of Lands, where at any point in time, we can go there to conduct a search. Your name will be there as the owner of the property. So these are some of the documents you will present to show you are the owner of the property. It does not matter in the eyes of the public. People think that maybe your husband owns a property and then after his demise, everybody's coming for the property. Once you show the deed, you show the power of attorney, and then it's even good to register it, because once it's registered, you go there, they see it. So it will be clear that it was not forged.
Right. So once all these documents are tested and proved,
yes,
then she's,
yes,
in this scenario, she's covered.
Yes, she's covered.
How does Nigerian law validate wills made overseas? This is a very important one. And how secure are they against family property disputes in Nigeria?
A will is not restricted by territory. A will is a will anywhere. And one of the ways that you authenticate a will that is written or that's from abroad is that there is what we call notarization of documents. Notarization of documents authenticates a document that it is a legal document. It is a document that has legal backing. Like most of the people that travel, you hear that they need to notarize their document. It gives it, particularly when the transaction is across borders. When it's across borders, there is a need to notarize documents. And sometimes when you bring a document over to Nigeria from abroad, you can register it. You can register a document in court. Once the document that is brought from abroad is notarized and it's registered here, it can be implemented, it can be used as a legal document to enforce what is contained therein.
Yeah, regarding this question, there was a trending issue about a lady, I don't know if you saw it on the internet, an Ifunanya lady who the father was held hostage by the siblings, and then her uncle, who is based in the US, came showing some documents that the father signed it a certain time. The father was in Nigeria, and it was approved by a court in the US. So people were like, this cannot be, this cannot.
Okay, you see, mostly public opinion does not really matter when it
Without
comes
the knowledge
to
of
the
how
knowledge of law and how things should be done. You see, the court of public opinion always ends in public opinion. When, particularly now, you said that he showed that it was registered in the court over there and all that.
Yeah.
When you bring such documents here, you register it in our courts. Like you get a judgment abroad from the courts in the US, anywhere. Once you bring such document, before you enforce it, you must register it here. Our court must recognize this document also before it can be enforced. So once a document is registered, it can be executed.
All right. How trusted are, how effective are trustees over estates? You know, people that are interested.
Okay. Once now, it's once a will or the letter of administration. A letter of administration is someone dies without a will. You want to distribute his assets. You first of all get a letter of administration from the probate division of the High Court, and it begins to administer how the will or the property will be shared amongst the heirs. Now, a trustee comes to play where the other heirs are minors. They are not, a minor is one who is below the age of 18. You need to get to the age of 18 before you can be entrusted. Now, a trustee, there is no specific rules to say if there are any guidelines. But you see, the will or the letter of administration can specify to say the trustee must be this, must be that, you must not do this, you must not do that. I'm going to say something about someone, it was in the public space. I'm not going to call name. The man passed on last year. He's a very notable figure. And his will just came out. And in the will, he said that his wife, the wife will only be entitled to his assets if she remains unmarried. I don't know where I saw that. So it's, if a trustee is to be appointed or has been appointed by a will, the trustee will be expected to carry out the details of his instructions, and if there are defaults in terms of the conduct in distributing the assets based on the dictates of the will, they can challenge it. The court is the avenue.
The court has every right.
The court has every right. You cannot deny the courts of that jurisdiction the right to enforce, to determine legitimacy of a will, the right to determine the distribution, or the right to even determine if a trustee or an administrator of a will is carrying out the instructions appropriately. If he's not carrying out the instruction appropriately, because it's all spelled out in the will. If the will is saying you are entrusted with this property on behalf of A, B, C, they are minors, and you hold the property in trust until they get to the age of 18 or to a certain age, or not only trust, not only minors. A will can say, this property is entrusted to you to hold for A, B, C until certain acts is done.
Carried out.
Until certain things are done. So what happens is that the trustee manages, holds that property in trust, and ensures that the heirs who are entitled by right to that property carry out those details, those instructions. And if the trustee is failing in his responsibility, the heirs too can challenge by going to court. And that will is the evidence to say you were asked to be entrusted with this property. You are not managing it how you're supposed to manage. You are not doing it. Then the law will determine
the investigation.
Yes.
All right. A family who probably adopted a child, a son, before the wife started giving birth to children, and there is no will after the man's death. What does the law do about that? And people are contesting that the first son, being the one who they adopted, should be the one to receive the rightful property as the first son of the family.
Okay, let me explain. Let me use certain regions to analyze this. I said in the Yoruba customary law on inheritance. Now we're talking about there's no will.
There's no will, yes. If there was a will,
there's what we call primogeniture principle. The principle gives the first male child the rights of control of the assets and estates of the deceased. It is a administration of estate law that says that first, even the court has, I'm trying to remember the case. I think it's Mojekwe against Mojekwe. I'm trying to remember, it's 2014. The law, it has to do with the Benin Edo State, says that firstborn son has rights over his father's property.
Whether legitimate or not?
No. Firstborn child.
Firstborn.
Yes, firstborn son. It has to be firstborn by birth.
By birth.
So it means that now an adopted child son can inherit. But you see that the preference is given to the first male child. It is that first male child that determines first before the property can be distributed amongst the other siblings who are heirs to the same, including an adopted child. An adopted child has a right to inherit assets.
But not the first, as the first male son.
No, the first male son is considered first.
That is very clear, you know. Thank you, Dickson, for your wonderful explanation to all these things. We learn every day. People go through these things, so they need to know the right source to go to seek for help and all that. Thank you so much for joining us on Unfiltered. I'm Emanuela Okechukwu. Bye.